Where's the sights guy?
Podium check, podium mic check, testing 1, 2. Podium mic check. Testing 1, 2. Sound good?
Good morning. Annual The Bench. I'm Mark Brown with Dade Legal Aid and Put Something Back. We want to thank all of you for attending, most of you for accepting a case. Thank you very much. We have a lot of cases and we really appreciate it. Want to thank our supporters, the Miami-Dade Bar, of course, the 11th Judicial Circuit, Kornreich and Associates, and the American Inns of Court. This was started 40 years ago by Jerry Kornreich, and we're still here today, so thank you so much, Jerry. With that, I want to have Amber Kornreich, as you all know, a fantastic attorney, your own right, happens to be Mr. Kornreich's daughter. Please welcome Amber Kornreich.
Good morning, and thank you all for being here for the 40th annual View from the Bench, and for the final time in this historic and beloved courtroom, 6-1. We express deep gratitude to Karen Lattis, Mark Brown, and Dade Legal Aid, to Lisette Sanabria, and to the dedicated court staff for their tireless efforts in making this event possible and for their commitment to our families and this community. Thank you to the Family Law Inns of Court for their partnership and support of this cherished tradition. To the Inns of Court President, Sydney Town, thank you for your example of tenacious leadership as you guide us into a new era of service and excellence, especially this year, a record-breaking year for the 31st annual Turkey Drive, providing Publix gift cards and holiday meals to survivors of domestic violence, youth in foster care, and the needy in our community. Thank you, Sydney, and to our past president, Steve Spann, for their extraordinary service. Today is particularly meaningful. Not only is this a hallmark year for the View from the Bench, but it also marks a moment to honor someone whose life's work has shaped the very fabric of family law in our state. It is my privilege to introduce not only my father, but a father of family law in Florida, Mr. Gerald I. Kornreich. Mr. Kornreich was the first lawyer in South Florida to be board certified in marital and family law 9 consecutive times. He was appointed to the Judicial Nominating Commission by Governor Jeb Bush, and at the Florida Supreme Court, he received the Tobias Simon Pro Bono Award, one of the highest recognitions for service in our profession. Most recently, the Florida Bar honored him with the 50-year Counselor Award for his half-century dedication to the practice of law. But his true legacy lives in the families whose lives he has changed, not only as an advocate, but as a voice of humanity during some of their most difficult moments. A former client wrote words that capture him better than any professional summary ever could. From the bottom of my heart, thank you for everything, for your faith, your kindness, your moral clarity, and your heart. You have made a difference in our lives that I will never forget. I truly believe in your half-century of practice, countless broken families have found a different ending, one with more understanding, dignity, and peace because of you. You stand as a role model for many lawyers, a shining example of what integrity, compassion, and wisdom in family law truly mean. You deserve to be remembered in history as one of the finest family lawyers of your time. These words reflect the lived experiences of generations of family who have found steadier ground because Mr. Kornreich stood beside them. His words remind us that all family law is not about litigation. It is about lives, futures, and protecting dignity when it is most fragile. As we honor this final view from the bench in courtroom 6-1, it is fitting that we welcome someone who has dedicated more than 50 years to ensuring that Florida families have a chance at understanding dignity and peace. It is my honor to introduce my mentor, my inspiration, my partner, and a true steward in our profession, Mr. Kornreich.
Welcome. Welcome to the 40th Annual View from the Bench Seminar. By the way, this is not all about me, just in case you were wondering. But when you have your daughter as your introducer, you're going to get a little extra. So this has been just everything for so many people. I usually don't tell this story, but in 1985, the first View from the Bench occurred. Okay, and I believe Liz Baker in the first row was there. We were just talking about it. And it's important for the judges to also know. So I was helping coordinate this with Judge Feeder, whose portrait is in the first of the building. And I had just come back from Milwaukee, and I had been specially admitted to try a guardian ad litem case, a custody case. And I sat down getting ready for the case, and there was a place. There was a table for the guardian ad litem, which this is a long time ago. This is over 40 years ago. And when we started doing the case, and the guardian got up and started asking questions. The guardian was like a lawyer guardian. And we came back, and I told Judge Feeder of my experience. And he said, well, why don't we start teaching guardians? Why don't we train guardians in our courthouse? And in this courtroom, we had almost 200 lawyers. We broke into the other three courtrooms, just so you all know. 4 judges, including Judge Korovic, Judge Feeder, people that were there at the time. And we literally trained the guardians. They did mock trials so that they understood what it would feel like, how to help a child, et cetera. So that's just context to understand what's really going on here and how much has happened. And then, of course, our family court bench actually first was created in 1990. Judge Feeder was the first administrative judge, and of course, we're so lucky to be led now by Judge Ruiz Cohn. But the important thing is also the judges that have been involved in 40 years have included a minimum of 4 federal court judges. Judge Scola, Judge Ongaro, Judge Leonard, Judge Bloom, all were on the family bench. The 3rd district judges, Judge Gordo, Judge Emis, Judge Fernandez, Judge Schwartz, and many others have all been on the family bench and all sat where you guys are and where you guys are, because some of them started out as lawyers. So this morning is really about tradition and transition. The tradition is what I'm telling you about, and the transition is this courtroom is going to be no more for us. So 40 years in a row we've been here, and now we're going to go to a new courthouse. But the important thing is, especially I want to recognize, by the way, the first rows has the Guardian Ad Litem award winners from years past. And it humbles me so much to see the work that these folks have done. Laura, Liz, Diane, Cindy, Brett, yes, Sydney, all of these people have done so much. And the reason it's important for our seminar is because, now I'm talking to the back rows, is because as you take a case, you will most likely take more cases over the years. And if this year is your first case, great. And if it's your second, et cetera. And you're going to see that it multiplies this over the years. So we've actually recruited over 4,000 guardian ad litems or pro bono lawyers in 40 years. And I think that's pretty remarkable. We're also going to pay tribute to one of the great trial lawyers and pro bono lawyers of our time, at least my time, Robert Joseph Berg. He passed, and we're going to pay a tribute through a video of him this morning. So our first speaker is going to be Judge Spencer Multack. Judge Multack is board certified in criminal law, and that is fantastic. So he has a high level, and he's really become one of the great educators of the family court. He's spoken at this seminar a number of times. I was at the Academy of Matrimonial Lawyers seminar recently, and there he was, leading it. So Judge Multack, please. Thank you.
Mr. Kornreich, thank you for that introduction. I don't know who you were speaking of, but. And thank you to all the guardians who are here and have done work for all of the judges. The work is hard, it's stressful, and I know as a judge and as the lawyer sitting here, we can't make the decisions we do for the families in front of us without your help. So thank you very much. So today, I wanted to address presumptions and proof in family law proceedings, specifically dealing with relocation and equal time sharing. And I picked this topic because I feel that presumptions many times get left at the gate in family law proceedings. Families come in, they want the judge to hear everything. Good morning, George.
You got a lot of people are running late because of traffic.
Yeah.
So they wanted to apologize.
Oh, it's okay. So I think a lot of times presumptions get left at the gate. Families come in, they want the judge to hear everything. The clients want the judge to hear everything. And in that process, who needs to prove what and what the burden of proof is sometimes gets muddled. It gets muddled for the lawyers, and it can get muddled for the judges also. So I wanted to take this time kind of as a primer and a refresher as to how we operate with presumptions and how we operate with proof. First and foremost, a presumption is not just a word. A presumption is a rule of evidence, and it's found in chapter 301 through 304. Presumptions are supposed to be tools that make the stream of litigation easier. It tells you that there is a fact that you can assume to be true. Now, presumptions don't always make things easier. Sometimes they can make things a little more confusing. If you've read any recent decisions from the Fifth, Second, Third, you would know that presumptions can make things, people can get confused on presumptions. So a presumption is an assumption of fact which the law makes from the existence of another fact or group of facts found or otherwise established. You can assume something to be true. So we start with that. There are two types of presumptions that we deal with, right? There's the presumption of producing evidence, and there's then the presumption that we normally deal with, which is the burden of proof. They're very different, and I think that things can get confusing if you start to mix these two up. So, just as a review, a presumption, yes. So the presumption to produce evidence is otherwise known as a bursting bubble or a Therian presumption, where something is true until there is some evidence that's submitted and the presumption goes away and is then submitted to the fact finder, typically a jury. For example, there's a presumption that if you rear-end someone, if you're the driver of a rear-end car and you crash into a car in front of you, it's presumed that the rear-end driver is the negligent driver. Now, if there's some evidence that's put forth before the court that can show some negligence on behalf of the front-end driver, the presumption vanishes, and the issue of negligence then goes to a jury to determine who was negligent, who was at fault. There's also a presumption, if your house ever falls into a sinkhole, that the report from the geologist who writes the report, that report is presumed to be true. We don't deal with that, but in my deep dive of bursting bubble presumptions, this is what I found. The other one is that we're all presumed to be sane, right? We are all presumed to be sane when we walk into a courtroom. In criminal court, if there is a contest as to sanity, then sanity goes to the jury to prove whether there's reasonable doubt that you were insane or there's not enough proof that you were insane and there's reasonable doubt to believe that you are sane. Back and forth. But that question goes to a jury. These are your typical bursting bubble, production of evidence presumptions. We don't really deal with these. What we deal with is the other type of presumption, which are social policy presumptions, that the legislature has decided these are truths that we can abide by and we will assume them to be true unless rebutted, such as the validity of a marriage, the legitimacy of children, the surrender of a child to a hospital. There's a presumption that if there's an order that says that you should pay a certain amount, it's presumed that you can pay that amount. There is the premise of equality in equitable distribution, and there's now a presumption of equal time sharing. I have a bunch of handouts also, so you can take a handout if you want. If you don't want to take a handout, you can leave it, but they're here for you, with all the case law and statutes pertaining to this. So let's talk about the process of proving. When a presumption shifts the burden of proof, the presumption remains in effect even after evidence rebutting the presumption has been introduced, and the jury must decide if the evidence is sufficient to overcome the presumption. What does that mean for family court practitioners, family court judges? For example, equal time sharing. There is always the burden that equal time sharing is in the best interest of children always remains with the court. That's always there. That is not a bursting bubble presumption. When you walk into court and you're trying a case regarding equal time sharing, one person says, I believe I should have equal time sharing. Other person says, well, I don't think equal time sharing is in the child's best interest. It is the person who does not believe that equal time sharing is in the child's best interest, they have a presumption to overcome. They're the only party that needs to prove the time sharing, the equal time sharing issue. The other party who is seeking, who believes equal time sharing is appropriate, they have nothing to overcome. That burden stays with the court. They don't need to come in and prove that equal time sharing is in the child's best interest because it's presumed that it is. And I think this is one area where people want to come in and tell the court why equal time sharing is in the child's best interest. You don't need to tell the court why equal time sharing is in the child's best interest because the statute assumes it to be true. Now, of course, you're going to come in and present evidence with regards to what a time-sharing plan will be because the court still needs to consider all the factors in crafting a time-sharing plan, but that's different. That's factors the court is going to consider to create a time-sharing plan, not necessarily evidence that equal time-sharing is in anyone's best interest because it's assumed to be true. That presumption does not burst, it does not go away. Who goes first? The presumption imposes a burden against whom they operate of proving the non-existence of the presumed fact. What does that mean? That means in any one case, one party, petitioner, may believe that equal time sharing is appropriate. Respondent may believe that it's not in the child's best interest. In the same case, the petitioner may believe that there's a piece of property that is non-marital, and the respondent believes the piece of property is marital. So as you go through the proof and you go through the trial, make sure to designate and articulate to the judge who has the burden into which particular cause, because the burden is going to shift depending on the issues in any particular case. It's always good to, try the case in compartments. We're going to try time sharing first. Who has the burden? Clean up the time sharing. Move on to equitable distribution. Who believes something is non-marital? Who believes something may be a gift? Make sure that these are compartmentalized so you can keep your proof in line and the judge can keep its proof in line. The burdens of pleading and proof attached to the party whom seeks to change the present state of affairs and who therefore should be expected to bear the risk of failure of proof or persuasion, which is what I just said. Now, we try our cases to a preponderance of the evidence, which is really the greater weight of the evidence. And this will be in the handout that you will be provided, but the definition of the greater weight of the evidence is found in the Florida Standard Jury Instructions for Civil Instructions, which is the more persuasive and convincing force and effect of the entire evidence in the case. It's just good to know, and when you're trying the case and when you're arguing to a judge, what it is that you're proving. What's the language that you want to use to convince the judge a burden has been met or it hasn't been met with regards to the greater weight of the evidence. Okay, let's talk about relocation. So it's a confusing statute because there are presumptions and there's not presumptions. Out of the box, the statute says, and highlights, we're going to tell you that there's no presumption for or against relocation. So you come in equal. You come in equal. And there's some language in here. A presumption in favor of or against a request to relocate with the child does not arise if a parent or other person seeks to relocate and the move will materially affect the current schedule of contact, access, and time sharing. The way that I read this, as you start the trial and somebody wants to move, the other side is not afforded a presumption that just because you're going to move, that it's not in the child's best interest. You still start on a level playing field. Now, does this mean that you can't consider as evidence when you review the factors, which I believe between relocation and parenting factors, there's 30 factors, right? Will the access to the child be considered as evidence? Well, if you read through the factors, yes. I mean, it's considered in there. Will access to the child be considered as one of the factors? Of course it's going to be considered. If you're moving to California, access is going to be an issue. Now, does it reset the presumption, and is the judge supposed to think, well, listen, you're already starting with 1 foot in the ditch? No. No. This portion just simply affects where you start. Again, from my reading of it, the consideration of evidence of access and contact is already within the 30 factors that the judge will consider whether or not relocation is in a child's best interest. Now, The parent or other person wishing to relocate has the burden of proving by a preponderance of the evidence that relocation is in the best interest of the child. If that burden of proof is met, the burden shifts to the non-relocating parent or other person to show by a preponderance of the evidence that the proposed relocation is not in the best interest of the child. So a relocation trial is a best interest trial. But there are two separate burdens. Each party is trying to prove something else. One is trying to prove the child's best interest, and one party is trying to overcome that burden once established that it's not. And this is where things can get a little muddy. Why? One, you're trying different burdens. It is best interest, it becomes mudslinging like many other things that we unfortunately have to face in family law litigation. What if there is a tie? What if after a judge's consideration, the judge finds that, let's say, it's equal. No one's really overcome the burden. And there's an issue of directed verdicts and how to communicate to the judge that you don't believe a burden has been established midway through trial. And this is important. All right, okay. You're never going to forget the difference between the two of these ever again. Directed verdicts are for juries. That's a jury issue. A directed verdict is made at the end of a petitioner's case or a plaintiff's case in a jury trial. I will tell you a brief story, and I'm looking around the room, there's no names named, but I was in a case recently. Within the last 10 days, the petitioner's attorney put on a case, and at the end of the petitioner's attorney's case, the petitioner stood up and moved for a directed verdict for himself. Okay, and so it made me pause. Like, where is the misstep or the misunderstanding of the law that you are moving for a directed verdict for yourself because I've proven everything, Judge? It's proven. Right? So, directed verdicts, juries. What we deal with are involuntary dismissals, right? It's a bench trial. We deal with involuntary dismissals. And this is where mistakes can be made. After a party seeking affirmative relief in an action has completed the presentation of evidence, any other party may move for a dismissal on the ground that on the facts and the law, the party seeking affirmative relief has shown no right to relief, without waiving the right to offer evidence if the motion is not granted. This does not mean that at the end of a petitioner's case in a relocation, for example, one side moves for a directed verdict. You are not weighing the evidence to establish whether or not there's been a meeting of the greater weight of the evidence. You are not weighing evidence. All you are doing is, can anyone answer the question? I think Brett Feinstein knows the answer. Or maybe not. So,
but it's not a directed verdict.
So, you're moving for an involuntary dismissal. At the end of the petitioner's case on, let's say, a relocation, all the judge is looking for is whether or not there's been a prima facie showing for relief. You are not stopping the trial and weighing the evidence to make a determination as the judge whether they've met their burden of a preponderance or greater weight of the evidence. This will lead you into error. So when you are arguing to a judge, I'm moving for a directed verdict. How come? The answer is they haven't proven by the greater weight of the evidence that it's in the best interest of the child. The argument is they haven't proven a prima facie case. There's not sufficient facts to grant the relief. It's a huge difference. It's a huge difference. For example, mom wants to move to Sarasota. And she wants to move to Sarasota because the Ringling Brothers Clown Circus is there, and she's always wanted to be a trapeze artist. Right? That's the evidence. Okay. That's not a prima facie case for relief. There's no facts that could establish that that is in the child's best interest. All right? Otherwise, it does not matter if the facts are contested, if a witness has been impeached. Is there sufficient evidence that could grant relief, that you could make a finding that it is in the child's best interest? Then it should be denied. So involuntary dismissals should only be granted where there are no facts in the light most favorable to the non-moving party that would support relief. Florida law is clear that a motion for involuntary dismissal made by the defendant must be denied if the plaintiff has presented competent, substantial evidence that when considered in a light most favorable to a plaintiff establishes a prima facie case. So as a judge, as the court, we are not weighing the evidence. We wait until all the evidence is presented to us in a relocation trial, and based upon all the evidence, has a burden been met? If so, has the other party overcome that burden? That is done in your office, on paper, with time to think. Equal time sharing. So, how do you reconcile the presumption of equal time sharing with the relocation statute? Well, there's a presumption for equal time sharing, Judge, right? How can we grant relocation when there's a presumption for equal time sharing? When two statutes appear in conflict, the specific statute controls over the general statute. The more specific statute is to be viewed as an exception to the terms of the general statute. So there is no argument that there's a presumption of equal time sharing when you're dealing with a relocation, because there's a specific statute on relocation that explains what the presumptions are. And so here we move into equal time sharing. Unless otherwise provided in this section or agreed to by the parties, there is a rebuttable presumption that equal time sharing of a minor child is in the best interest of the minor child. To rebut this presumption, a party must prove by a preponderance of the evidence that equal time sharing is not in the best interest of the minor child. As I said at the beginning of this presentation, the party who believes equal time sharing is appropriate has no burden. They imagine will present evidence to establish the creation of a parenting plan for purposes of establishing or modifying a parental responsibility and creating, developing, approving, or modifying a parenting plan, including a time-sharing schedule. You are to consider these factors. Evidence is presented to consider factors, but it's not presented to establish a presumption that you already are entitled to. What about equal time sharing and temporary time sharing? We all have motions that come in, Judge. I want equal time sharing as temporary time sharing because I am entitled to equal time sharing as temporary time sharing. No, you're not. The presumption applies to a hearing where you are determining the final adjudication of parental responsibility and developing a time-sharing plan. It is in the creation and establishment of parental responsibility. It is not built into temporary time-sharing. The goal of temporary relief hearings, however, is to promote stability in the lives of children while the divorce is pending, not to decide the final outcome. And as many of you may know, The court does not even have to go through the factors when establishing a temporary time-sharing plan. It's temporary. There will be time for a final hearing where you will attack these presumptions. When someone will come in and say, I believe I should have equal time sharing, I don't believe you should have equal time sharing. That's the time these presumptions come into play. They do not come into play when you're dealing with temporary issues. And so hopefully, this presentation may be a reminder. I have lots of handouts so you can recall and argue to the courts and prepare your clients as to who has the burden, who has the proof, and what we're doing in court when it really comes to overcoming presumptions. Thank you.
Sherry, you can be in this picture. We just, Judge Maltak, thank you very much. Get the bottom of the box, right there. You done?
Yeah, I'm done.
Thank you. Thank you, Judge Maltak. On behalf of Legal Aid, we're very grateful for your time and your dedication to the program. We heard a little bit earlier about transition. We have a new courthouse, we have a new home, but there's one staple and driving force that has never wavered. There's only one Jerry Kornreich, and there's only one view from the bench. So, on behalf of Legal Aid and the thousands of lives that you've improved over the past 40-plus years, we are honored to present you with this special award in honor and of your dedication and your commitment to the view from the bench and to recruiting the thousands of guardian ad litems you've done so over the years. Thank you. You have a special. In the middle.
Thank you. Thank you so much.
I'll take it if you want. Just leave it.
You think this was like my birthday party or something? It's like, fabulous. All right, thank you, Judge Maltak. All right, here is Judge Veronica Diaz. Judge Diaz was also caught in traffic. I guess you all guys are starting to come in. Thank you very much for the, bearing with the delay. Judge Diaz attended FIU. She also got her law degree from the University of Florida. After law school, she became an assistant city attorney. Most importantly to me is that Judge Diaz has been teaching us at this seminar for the last couple of years and helping to recruit you guys. So, Judge Veronica Diaz, thank you.
Good morning, everyone. Thank you so much for being here today. What an amazing milestone we're living right now, 40 years. Thank you so much for what you have done for our community. The guardians that have walked through this courthouse and our family courthouse and all the other courthouses have a lot to do with your pushing them to get them here. And our families are better served because of your dedication to this program. And Amber, no pressure, but at some point, Dad's gonna retire, so let's see what you got. All right. All right, so let me start out with one question that I suspect is going to resonate with a lot of you here. By a show of hands, this is an easy one, please help me here. If you had $1 for every time you encountered a vexatious litigant in your practice, how many of you would already have a full piggy bank? I should see every hand up here. I know the reality. I know all of you do. Well, all of you who raised your hands, thank you. Who's going to buy us lunch? Wonderful, wonderful. So as family law attorneys, you know this reality better than most practitioners. You've seen the names appear again and again, the same motions recycled, the same relentless attempts to relitigate issues that have already been decided. Sometimes you can practically predict the filing before it even hits the docket. Sort of like deja vu, but with way more paper and way less charm. It happens to all of us. These cases don't just drain judicial resources, they drain families, children, and the integrity of the process itself. And if you've ever had to explain to a client why their case is delayed because someone is filing their 10th emergency motion, you understand exactly how this issue has frustrated you in your practice. Luckily, the legislature actually helped us. They don't always do, but this year they did. Effective July 1st, 2025, the statute 68.093 has been revised, and it gives us sharper tools to distinguish between due process and abuse of process. Today, I'm going to walk you through those revisions, highlight the expanded definition of a vexatious litigant, and share how, from the bench, these changes can help us manage the most difficult cases while still safeguarding fairness. Along the way, I'll invite you to reflect on how these changes may affect your practice, hopefully without needing to file a motion for extension of time. I will share one quick story from a recent docket. A litigant recently filed 3 emergency motions in a single week. Each one, obviously, was styled as an emergency. None of them involved any actual emergencies. One was about the color of the child's backpack. Another was about who was the parent who was going to start pickups on Fridays when school started again in January. The third motion, this was great. The cereal the child was eating was not appropriate. It had palm oil in it. Ooh. So, by the time I got to this third motion, everyone was thinking, even opposing counsel had joked during a hearing, that we needed an emergency motion just to stop this litigant from filing emergency motions. It happens. It's the reality of what we're willing with. So let's talk about what has brought us here today. The legislature's intent was clear. We have the right to crack down on repetitive, meritless filings that clog our dockets and delay justice. Think about the impact in your practice. Every frivolous motion consumes time that could be devoted to an actual dispute regarding child custody, time sharing, a real domestic violence injunction, or a legitimate appeal. The changes to 68.093 broadens both the definition of a vexatious litigant and the authority of judges to intervene. It's about protecting the judicial process while preserving access to courts for legitimate claims. So before we dive in, I want everyone to say 10 times really, really quickly, vexatious litigant, vexatious litigant, vexatious litigant, right? It's sort of not something that easily rolls off the tongue. Before we dive into the statute itself, let's take a moment to reflect. Think about your recent cases. Has litigation ever felt like it's less about resolving an issue and more about just exhausting the other side? I see it. I see it every day. I can only imagine how frustrating it is on your end as practitioners. How does that affect your work, your practice, your clients? How does that affect the children involved? How does that affect the court's resources? It's all pretty frustrating, right? I'm going to ask you to think about one word or a short phrase that captures the impact of that experience on your firm, your practice. Maybe it's delay, maybe frustration, maybe costs. Hold on to that word because the revisions to Section 68.093 are designed to give us tools to address exactly those kinds of situations. And I do have a PowerPoint. I am not a PowerPoint creator, so I would like to thank the 11th Circuit and our resources, the magical Erica Ruiz, who sprinkles fairy dust on every PowerPoint presentation and makes it so pretty. Thank you, Erica. So, what do we have as the court's inherent authority? Before the statute changed, the only way that courts could deal with vexatious litigants was through the inherent authority to protect the judicial process. Now, show of hands, if you've ever had a case where opposing counsel or a pro se party filed appeal after appeal with no legitimate basis. I know at least one of you out here, right? Frustrating. Well, that's the scenario that we find in Sibley versus Sibley. That is exactly what the court there addressed. In Sibley versus Sibley, sanctions required the former husband, who himself was an attorney, mistake number one, to be represented by counsel after filing 25 appeals, prevailing in only one, and repeatedly relitigating settled matters. He even filed a dozen federal actions against judges, the court system, and his former wife. In Clark versus Bainey, the first DCA affirmed that a court may bar a litigant from appearing pro se when frivolous filings interfere with timely administration of justice. It happens all the time. Some litigants just don't think that the word final in a final judgment really means this is the end. They see it more as a suggestion that maybe they should treat the filing system of cases as a subscription that never ends. Let's just file things, file things, file things. It's frustrating to us, as I know it's frustrating to you. Imagine being opposing counsel in the Sibley case. Imagine the drain on your client, the cost, the emotional toll. Before the statute change, the court's inherent authority to achieve fairness was the only thing we had as a tool to combat these vexatious litigants. The statute, luckily now, codifies and strengthens our authority, giving us one additional tool. For practitioners, here's a tip. This means you can cite to the court's inherent authority when opposing repetitive filings, in addition to the newly revised 68.093. Remind the court whenever you feel you need to that it is our obligation to make sure that the process is fair for everyone, and that includes making sure that the process is protected from vexatious litigants. Not all matters require a hearing. Raise your hand if you've ever sat through a Zoom hearing where you thought, this could have been an email. Or, better yet, no hearing at all. And I want you to give yourself bonus points if you've ever muted yourself just to go, we do it. We understand. It's frustrating. We've all been there. We stare at the little boxes, waiting for an argument that never has any substance. These revisions help us make clear if a motion lacks a colorable basis, the court can act without convening everyone, whether in person or on Zoom. While we want to be efficient, fairness has to be our guiding principle. Not all matters require a hearing. For example, motions for the appointment of a guardian ad litem do not need to have a hearing. It says so right in 12.942A. It is possible that there will be a hearing on your motion. The judge may want to hear the reasons you feel an appointment of a guardian ad litem is necessary, or the other party may object to your motion. That means I have a really, really big practice tip for you. At least in my division, verify these pleadings. If your client has signed a verification on a motion to appoint a guardian ad litem, I can take that and I can now use that as a tool to expedite the process. Without the verification, you're lucky if you're maybe looking at a 3-week period of time to get a hearing, 15-minute hearing on my calendar. That saves you 3 weeks if you've simply had your client verify the pleadings. That's something the court can rely on. This is the new 68.093. I'm not going to sit here and read it all, but I'm going to tell you about the changes. It's important to know that we now have an expanded definition of the word person. So normally, when you hear the word person, how many of you think that when you see it in a statute, it goes beyond individuals? Well, I've had cases where the person is actually a trust, a corporation, and then I think, great, I'm litigating a spreadsheet here. So it's important to know that even corporations who are supposed to be represented by lawyers in anything other than small claims court are subject to this. So it's important when you're looking at the big picture that you understand all of the litigant's history is going to come in. Whether it's a parent in a custody dispute, a trustee in probate, or even a small business owner in small claims, the statute applies. It ensures that the abuse is addressed regardless of the form the litigant takes. So what is important to note? Other than the expansion of the definition, a person, there's also an expanded time period. Why does this expanded time period matter? Well, it gives us more of an opportunity to determine how long has this person been doing this. If this person has been doing these filings for the last 7 years, that is clear evidence to a court that that person, entity, whatever the form of the person is, can be considered a vexatious litigant. The other important change is that we now include the language in subsection 5 has been previously found to be a vexatious litigant pursuant to this section or by another state court or a federal court. Think about this impact. You have a litigant who has been blowing up the federal filings, right? And you think, well, I get a filing here in the family division, and right away, this litigant is really annoying. This litigant is papering. On top of the fact, he's likely not sending you the motions, because why would they? That's what pro se litigants often like to do. So now you can use their history in other courts to prove to the judge in your state court that the person is a vexatious litigant. The other important change is that the court can now deny the vexatious litigant request for relief without needing hearings, just based on the information before the court. We also have the addition that the statute applies to all sorts of actions. That means pre-judgment and post-judgment action. And it's important that you cite this in motions that you present to the court where you're asking the court to find someone as a vexatious litigant. It's going to help you tee up your argument and give the court the teeth that it needs in order to be able to rule in your favor. So, if you've ever felt like you are living Groundhog Day, where the pleadings are repetitive, the filings are the same, and you're frustrated because, let's be honest, Bill Murray never really shows up to rescue you, you now have a tool to say to the court, please help me so that I can be more efficient and the system can be even more fair for my client. The numeric threshold used to be 5 cases. I'm sorry, it used to be 5 years, as I stated. Now, it's 7 years. The expansion captures more litigants while avoiding what some decided was an overly harsh cutoff. I personally think 5 years of repetitive filings, but the legislature has decided 7. So that gives you the opportunity to look back and see if this person has any other filings of a similar nature in any other court. And you can use that to argue in your case that the court should be deemed a vexatious litigant. It's important to note that other states like California and Texas, they have similar statutes. So this latest revision aligns us with a broader national trend, recognizing that their numeric thresholds alone are insufficient. Conduct matters, and we now can use a person's conduct to make sure that they are not hampering the administration of justice. Speaking of pro ses, do we have special treatment for pro se litigants? I see all of you shaking your heads no, and that is correct. Courts have consistently held that pro se litigants must meet the same standards as licensed attorneys. The third DCA stated in Cone versus City of Miami Beach, compassion for a pro se litigant and justice under the law are entirely different concepts that should not be confused. While empathy is required as judicial officers, we do not have to indulge them in allowing them to file all this. Fairness does not equal indulgence. I'm sure it's happened to many of you where you've read a pleading by a pro se litigant and you have to read it again and maybe even a third time just to figure out, what is this person asking for? We want to curb that. And while we want to respect access to the courts, we can't allow repetitive meritless filings by pro se litigants. They overwhelm the system. The revised statute reinforces that equal standards apply and gives us as judges more discretion to curb abuse when those filings become excessive. About 4 years ago, I received a a pro se motion, and it was titled, Motion to Correct the Universe. I wish. Unfortunately, the legislature hasn't given me that power yet. It was very creative, but it doesn't help the case. And it was one of half a dozen filings that this particular pro se litigant kept putting before me, kept saying they were emergencies. It really happens, and it's very frustrating. Beyond the numeric threshold, the statute now empowers judges to deem litigants vexatious based on just conduct. This includes relitigating final determinations, filing repetitive motions, engaging in frivolous discovery, or using delay tactics. Qualifying conduct in federal courts or other state courts may be considered. So a litigant who has abused the system in Georgia decides they're going to get in their car and drive down to Florida and start messing with us here in Dade County. Now, when you can look up their history and see that they've done this in another jurisdiction, you can put a stop to it here in Dade County. You should always research litigants' histories in other jurisdictions, because you can show us the repetitive filings in another jurisdiction in order to support your argument. Florida's 2025 revisions broaden who may be deemed a vexatious litigant. The law moves beyond numbers to encompass abusive litigation conduct, giving judges increased authority to protect the judicial process. Now, think back to that word you jotted down or thought about at the beginning of my presentation, whether it was delay, frustration, cost, or something else. That word captures the lived experience that you have had in dealing with vexatious litigants. What the legislature has done for us is it's revised the statute in an aim at reducing exactly those burdens so that the court can focus on delivering justice rather than managing abuse. Our role is to apply these tools with fairness, ensuring that due process is preserved while abusive process is curtailed. It's about striking the right balance, protecting access to the courts while preserving its misuse. Also, it has a lot to do with restoring confidence that the courts are a forum for resolution, not a weapon for harassment. These revisions are unfortunately not the end of our conversations. I don't know how many of you have seen an uptick in recent pro se filings that look and read a lot like something you would write. Welcome to the world of AI. The world of AI has given vexatious litigants yet another tool to use against us. But now, because the legislature has amended this statute and expanded the definition of a person, expanded the time frame where the court can look at the filings by a pro se litigant, we understand that we're going to have to adapt and continue moving through the new world that AI has brought us. But don't let that be the reason that you stop bringing vexatious litigants to the court's attention. A lot of times, we don't see all the filings. I wish everyone would include my division email address in the service box, 11th FC19 at jud11.flcourts.org. I get those directly in my inbox, and I can see if a litigant is filing motion after motion after motion. But if you don't include my office, my division in your service box, I may never know. So I need to rely on you to bring it to my attention. It is important that you file these motions, that you include the information from every jurisdiction you have found, and that you list the examples, every single one of them, where the litigant has conducted discovery that is completely unnecessary, every emergency motion that has no emergency basis, every motion seeking relief that has already been addressed by the court. When you bring these things to our attention, we will act on it, because now it's not just a principle of the court's inherent authority. Now we have a statutory scheme that will support your motion to find someone a vexatious litigant, and it'll allow us to help your practice be more efficient so that you don't have to have that uncomfortable conversation with your client about a hearing being canceled because there's an emergency filing by the same litigant addressing the cereal the child eats for breakfast. Thank you so much for your attention. I hope you learned something this morning. I always find it awe-inspiring that all of you practicing professionals are willing to sit here and listen to us talk about anything. Honestly, I could never pay the hourly fees of the attorneys sitting here. And I continue to thank you all for volunteering to be guardians. We can't do our work without your assistance. We can't make the decisions that we need to make for our families and for the children in our system without all of your participation and all of your support. Thank you so much for making the time to be here, fighting crazy traffic this morning, and spending your Friday morning with us.
Thank you. Here, I want you to know there's a scratch. I just pulled them. I'm so upset. Thank you. Thank you so much, Your Honor.
Thank you. Always a pleasure.
Sure. I think you're in front of the thing. I think that, I owed you a new one. I'm so upset. Thank you very much, Judge Diaz. I also want to just take a moment to recognize Lizette. Lizette Sanabria Didi and the courts. We couldn't put on this seminar or anything without you. You're an angel behind the scenes doing everything for us. I know you wear many hats, but really to legal aid and to this program, you're an angel. So thank you, and we have a plaque for you too. Thank you. Here you go. Thank you. Awesome. Thank you so much. Thank you.
Thank you, Judge Diaz. Now, at this point, we're running a little late, and I apologize for that because of the traffic and all. Karen's father was a fellow named Robert Joseph Berg, and he was a well-known lawyer, and he did an awful lot of pro bono work. And we tried to figure out how to do a tribute to him, and I thought maybe the best way is for you to see him. So what we're going to do is we're going to show a video. Mr. Joseph Berg, myself, and Paul Lipton did a professionalism panel, actually 3 of them, for the Florida Bar, the Dade County Bar, and of court. And we captured him. Unfortunately, you have to bear with me because there's going to be 6 minutes of me also. But nevertheless, I want you to meet Robert Joseph Berg.
Up to, and he's jumped in right when I started at Legal Aid a little bit over 30 years ago to be a leader in pro bono and professionalism. He's the founder and senior partner of Kornreich and Associates. And for over 4 decades, he has been practicing family law, and he's a fellow of the American Academy of Matrimonial Lawyers, the International Academy of Family Lawyers, and the National Board of Trial Advocates. He's also the first lawyer in Florida who's been board certified by the Florida Bar in marital and family law 8 consecutive times, and he's still going strong. We're so lucky that we have Jerry's longstanding commitment to pro bono and professionalism. He received the Tobias Simon Pro Bono Award, the highest honor in our state, the Burton Young Award, the Maurice Kuttner Award, and on. But since we only have a few minutes for each speaker, I'm going to have to cut on the awards just a little bit. He's chaired and led the View from the Bench annually, which is one of the largest pro bono recruitment efforts in our state. So, Mr. Kornreich, you are an example and a leader in our community. Why do relationships matter in the professional practice of law?
Well, thank you, Karen. And of course, I'm super honored to be on this panel, especially with Bob and Paul. These are just incredible lawyers, and the judges, Karen and Amber. Oh my God. You know why I'm honored? I'm honored because it's about our relationships and professionalism. Whenever I come on, I try to discuss not rules, not statutes, but really how do you become a professional? How do you become civil? Well, the honest answer for litigators especially, but all lawyers, is from your interactions with each other. And I'll tell you a story. We lost one of the legendary lawyers, Burton Young. Burton Young was president of the Florida Bar, 96. He just passed, and I went to his funeral 2 days ago. And you say, well, it's a funeral, okay, it's going to be a downbeat kind of a thing. There were about 300 people. I would say the majority were lawyers. And I looked around the room and I realized that I had interacted at some point with almost everybody in the room. There were judges, there were lawyers, there were all different kinds of lawyers, bar people, all kinds of things. And I also realized, because I was thinking, boy, I'm going to have to make a presentation in a few days about professionalism and relationships. What do the people in this room think about me and how I practice and who I am? And although I didn't know the answer, and I don't know the answer, I realized that we all do judge each other, and primarily on how we have treated each other, how we have been civilized to each other during litigation or during somebody's illness or during a bar committee meeting or doing pro bono work. All of those things are the relationships that build lawyering and that ultimately lead to professional. So I wanted to say that we should honor Burton Young, who was one of the great professionals, literally, of our time. He was a mentor to me and to others. And quickly, I'd say that from a relationship standpoint, why is important? Well, I met Paul and Bob Josephberg both as adversaries, in both in bad cases. Now, we were younger and more aggressive and more feisty and everything, but nevertheless, we met in bad situations. And with Paul, right before a deposition, we sat down. He said, come into my office for a second. We were fighting. We were fighting terribly. Come into my office before we start. And we were staring at each other. And I asked him about his wallpaper. And now I'm looking behind him now. And he said, yeah, my wife picked this wallpaper out. And I said, I have it in my office. And now it's 40 years later. And we're great friends. And if I had a problem, I would call Paul and say, I'm having this issue. And I did do that in my lifetime. Once he actually sat with me when I had a crisis in my practice about how somebody was treating me. And I said, Paul, tell me, what I should do. So these are the relationships. Then with Robert, I had a matter where he called me out of the blue. And everybody in my office said, Robert Josephsberg's on the phone. And I was, oh my gosh, what do I do? Because I couldn't, we had phones, we had regular phones, right? And I said, hello, Bob, how are you? And he said, Jerry, listen, I got this matter with you, and I don't usually do family work, but it's a significant case, and I wondered, what does the judge do when we start this type of a hearing? And I said, oh, okay, Bob, well, glad, welcome aboard. And this is how this particular judge likes to start the hearings. And this is what, this person will go first, and this is whatever. And we hung up, and he said, thanks, I just wanted to get the lay of the land. I wanted to understand. And we've built a relationship over 30 or 40 years to the point that when Karen puts on her Christmas party for legal aid, and we sponsor it, Robert is the Santa Claus. Okay, this is what leads to professionalism. He's going to know if I'm doing bad things in the community. I'm going to know what he's doing. And lastly, I would say, from a standpoint of relationships and how important they are to lawyering, Karen mentioned, Karen and I, so 4 people on this panel I have a significant relationships with. Karen and I have done a seminar for about 33 years together. And since she was a young lawyer, and that's a pro bono seminar. So I've had, we're not doing cases with each other or against each other, but I've gotten to know her and she's gotten to know me. And in our community, that's another way where you can interact and learn more about what's going on in your community and how people are acting. And believe me, everybody is judging your conduct. And lastly, my daughter Amber is on this panel. And that would be enough. Of course, I would be very excited to have her on the panel, but it's more than that because she's my partner and my colleague. And I would say that literally every day we do all of our cases together. Every day we discuss issues regarding ethics and civility and what we should do and how should we do it more professionally. And you know what? We don't always do it right. And we screw up. And even after talking to each other, we come to the wrong conclusion. But I would suggest to you all that you should seek out a colleague, that you should seek out a friend. You should take out somebody when you're having one of these really tough ethical, moral issues and talk to the person and don't act impulsively. And maybe you'll come to the right conclusion. Thank you.
Thank you so much, Mr. Kornreich. And for me, it's truly an honor to be your daughter and for you to be my father. And you're really more than just my father. You're a father of family law in Florida. And just you're a role model. You really practice what you preach, and you've set a standard for authenticity and integrity. And thank you so much for sharing that with me, with us, and all that you do to be a role model to me. So now I have the tremendous pleasure of introducing Karen's father, the legendary Robert Josephsberg. Robert Josephsberg is a partner at Podhurst Orsak and is one of the nation's most successful and widely celebrated trial lawyers. He's a trailblazer who embodies the epitome of compassion and leadership, both professionally and within his family. Karen, his daughter, is here with us today. He's a recipient of the Florida Bar Criminal Law Section Selig Golden Memorial Award, the Greater Miami Jewish Federation's Ted Klein Award, and Mr. Josephsberg has been named as one of the top 100 trial lawyers by the National Trial Lawyers Organization and inducted into the Trial Lawyer Hall of Fame. He has broad pro bono experience, having also received the American Bar Association Senior Section's Pro Bono Award, the Florida Bar's Tobias Simon Pro Bono Service Award, and the Florida Bar Foundation's Medal of Honor Award. Thank you so much, Mr. Josephsberg, for being with us today. From your experience, what are your expectations for professionalism from other attorneys?
I expect great professionalism, and I don't always receive it. I've been practicing for 62 years, and the professionalism has to some degree diminished. And the reason is that the bar is about 4 times as large now as it was when I started. And the basis of professionalism is interpersonal relationships. And as I look at this panel, it reminds me of what interpersonal relationships are about. Now let's take Chris McAlally. I had a very difficult case against her when she was a federal prosecutor in the U.S. Sugar case, if you remember, Chris. What is it, 40 years ago, 50 years ago? And one of the factors I had, although I want to and try to be nice at all times, I had added pressure on me with that case. I had practiced law with her father, Tom. I knew her mother from the school board, and her brother, Neil, had clerked for me. And it's just a matter of ego. The idea of her telling any one of the three of them that I was behaving like a bully or a jerk just would have destroyed me. And so, for very simple reasons, I behaved. And she and I got along very well, although some of her clients and some of my clients didn't get along well. But we had the reason of a personal relationship. And along those lines, you know, Judge Fay, back when he was in the district court, hated discovery arguments. And what he would do when lawyers came before him and he couldn't push it off to his mag judge, he would say, I'm not going to rule on your discovery. What I want the two of you to do is go out and have lunch together. Don't discuss the case. Just discuss your lives. You may find out that your kids go to the same school. You may go to the same religious organization. You may have friends in common. And after you have that lunch, if the two of you cannot resolve your discovery, come back here and I'll make the rulings. No one ever came back. Because when you find out about the interrelationships, you start behaving differently. It's very difficult to be nasty with someone who has mutual friends with you and someone you like. And that's what's missing today. There are so many lawyers that don't know each other. And my attitude has been, as Jerry said, when I'm in a new case and I don't know what I'm doing, I'll call my opponent. I'll have lunch with them. One of the best things to do when you start a case is call your opponent and say, let's have coffee, let's have lunch, let's talk. Assure him you're not going to set depositions at times that are bad for him. You'll always have to mutually agree. Just make it clear that you're not going to be a bully or a jerk. And part of the problem is that some lawyers, young and old, think it's very macho to be a bully. And they don't realize that you lose ground that way. You know, all of us have, to some extent, ego-wise, we want to be well-liked. And if I have to look back on my 62 years, I don't think about any of the big cases. I think about the relationships, the friendships. And I would like, when I'm walking down the street, and on the other side of the street is opposing counsel or a former client, and we don't just keep walking away from each other, we cross the street, shake hands or hug. As a selfish matter for me, I want to be liked. And the only way to be liked is to be likable. And that's what professionalism is about. And it starts at the bench. So I had a large and very difficult case in front of Judge Demetrius. And my client was impossible. And the judge treated him so kindly, ruled against us on everything appropriately, but set an atmosphere that was so pleasant that you couldn't be upset. And when judges set a pleasant atmosphere, and everyone else does, the practice of law becomes so much nicer. You know, the reason I'm still practicing is I've got enough money, I've had enough glory. I love practicing law because I love the relationships. And the only way that you'll have those is if you make the first move of kindness. Be nice. It's that simple. The bar can have all sorts of hours of rules and 2 hours videos, etc. But it's really just simple. Listen to what your mother told you. Be nice to people. And you'll find that some of the biggest jerks, when you're nice to them, they melt. They don't know what to do. They're shocked. And you tell them, sure, we'll have the deposition whenever you want. We'll do this, we'll do that. Because, you know, most of these little things that we argue about aren't worth arguing about. Just so my lesson from the whole thing is, if on a selfish level you want to be happy, to be happy, you need to be liked. And to be liked, you have to be nice. So that's my message for professionalism. You know, do unto others as you'd want others to do unto you. And the relationships. The other senior partner in my firm, I started off trying a case against him 60 years ago. Other people who have been my opponents have become my best friends. You know, 4 guys every Saturday or Sunday go out, play tennis or golf. And they switch each week, the teams. Dave plays with B against C and D, and they keep reversing. And during the tennis match, you don't stop and say, God, CD is a liar. He makes bad line calls. Next week, he's your partner. And you got to realize it's the same thing in the practice of law. Today, we're opposing each other. Tomorrow, we're co-counsel. We're all in this together. And if you want to try to make it miserable, believe me, you will get misery in return. And just be nice. You'll love it and you'll be happy. That's what professionalism is about. If any of you have any questions, I'd be glad to answer them. The first thing I'll answer is that Jerry and I are not here voluntarily. The only thing better than being ordered around by your wife is being ordered around by your daughter. And they have told us during the seminar, we're here involuntarily and we love it.
Thank you.
We love it. Thank you.
Thank you so much for your words of wisdom and just for being such an incredible role model to all of us. And I'm glad you mentioned our judges, because in addition to having the tips from the seasoned pros, we are very, very grateful. We also have 2 esteemed members of the judiciary.
We just wanted to share that to see what a great lawyer felt and thinks and what we all should probably do. We're going to move, again, we're running late, so we're going to move into the awards ceremony, and then we'll take a break. It'll probably be a shorter break, okay? Thank you. Also, Judge Beovides is also here, Deputy Chief Judge, and we want to acknowledge her, and she's going to help give out the award.
We do want to mention that Judge Beovides was an esteemed lawyer practicing with Dade Legal Aid for a decade before she joined the bench. All of her colleagues at Dade Legal Aid are here today and would like to come forward just to present her with a very special plaque to the Deputy Chief Judge, Honorable Gina Beovides. It was such a pleasure getting to work alongside you and with you. And now we're just honored that we can call you the Honorable Deputy Chief Judge. So on behalf of Legal Aid and your colleagues who are here, we do want to present you, a little belated, but very timely, since you're now the new Deputy Chief Judge. And thank you for your service to the legal aid community, to the legal community, and to the judiciary. Thank you. Come on up. Surprise. Where, you guys, please come up. Alex and Lisa. And Alexa, and Stephanie, and Amanda. Do you work at Legal Aid? Mr. Paulson? This is the Legal Aid plug part. We have an amazing staff of attorneys that are practicing family law, and here they are.
Sorry, everybody.
It took about 6 attorneys to replace her, so that's how we grew. Thank you. And then you get to give the other award. I guess someone's taking a picture.
Yeah.
Yep.
Thank you.
Thank you.
Thank you. Thank you, guys. All right, good morning, everyone. It is an absolute privilege to join you for the 40th annual View from the Bench, a program that has become the cornerstone of family law practice in Miami-Dade County. As been previously mentioned, today is the last time that this seminar will be held in this historic Dade County courthouse. For me, I love history, so knowing full well, and for those of you, if you didn't know, this building was everything when this Miami-Dade County was started. This was City Hall, this was County Hall, this is where the mayor worked, this is where the judges worked, this is where all business happened, this is where the jail cell was first built. In fact, for those of you that speak Spanish, one of the other surnames for this building is called Cielito Lindo, a beautiful, beautiful sky. And that was named from the prisoners that was held in the top floors because they could see a little bit of the sky. That's all they could see, and that's kind of the name that they gave. So there's a lot of history to this place. And for me, it's so fitting that not only is this the last time this seminar will be held here, but this is in fact the last of any ceremony or seminar that's going to be held in this building because we are in a process of moving. And in fact, business will start in December in the new courthouse. So it's fitting that the final gathering and the closing of this professional chapter of this courthouse is dedicated to the work that we do for families and children of Miami-Dade County. Now, I speak today on behalf of our Chief Judge, Ariana Fajardo-Orshan, and from personal experience. Having served the last 2 years in the family division, and I still maintain a part of this docket, I know firsthand the extraordinary commitment that this area of law requires. I'd like to extend my sincere appreciation to its administrative judge, Samantha Ruiz-Cohen, whose leadership, steadiness, and compassion anchor this division. I'd like to express my gratitude for all judges in the division, and this includes the general magistrates and the hearing officers. This work is demanding, often emotional, but always consequential. On behalf of the chief, my other Deputy Chief Judge Cuesta, and I, we are extremely grateful for the work that you all do. But we're not alone in this work. I'd like to also take a moment and thank the Division Director, Lisette Sanabria, as well as the case managers in the family division. They are the ones who keep things going behind the scenes so that we can produce the best product we can to the decisions that we make. But of course, the family bar is an essential part of advancing justice. Year after year, your preparation, professionalism, when otherwise not vexatious, and advocacy ensures that even the hardest cases are handled with dignity. Events like this don't happen on their own. I want to thank the partners who make the View from the Bench possible year after year. Mr. Kornreich, the American Inns of Court, the Miami-Dade Bar, and of course, the place that I called home for 10 years, Dade Legal Aid. Your collaboration ensures that our bench and bar can learn together, grow together, and better serve the families who depend on us. As mentioned, we're here to honor the legacy of Ray Pearson Guardian Ad Litem Award, celebrating those who have gone above and beyond for children in our community. Please join me at this time for recognizing their past recipients. Laura Fabar, Ms. Fawad. I would also point, she's a magnificent pickleball player. She is my pickleball partner at times. So we do play, and we welcome anyone who wants to join us on Tuesday afternoons. Anna Martin Lavielle, Bob Merlin and Robin Buckner, Bet Kuwait, Brett Feinstein, Jacqueline Valdespino twice, Gerald Kornreich, the late and great Darlene Schweitzer Ramrez, Raquel Rodriguez, Mary Raymond, Carolyn Howard, Margaret Foley, Diane Van Ness and Richard Barron, Anastasia Garcia and Elizabeth Baker, now Judge Tanya Brinkley, Dr. Miguel Furby, Louis Padron, Ellen Silvers, Dr. Mary Haber, Cindy Kamen, Gregory Bredencourt, Diane Trainer, Linda Luce, now Judge, Regula Siblium, Chastity Perez, Nora Rotella, Amber Glasper, nice shout out, Miss Kathy Grass, and Patricia Mesa. Congratulations to all of you. You all embody the very best that our profession offers: service, protection of vulnerable children, and unwavering integrity. As we prepare to move on to the building, the new courthouse, the Osvaldo Soto Miami-Dade Justice Center, I hope we carry on the spirit of this building, the collaboration in this room, and the commitment that has defined the 40 years of this program. It is a great honor that I get to speak to you today, and thank you.
So good morning, everyone. So the Ray Pearson Gal Award is an award that we consider an extremely prestigious award. The way that the recipients are actually awarded and recognized is that every year the judges and the general magistrates vote on the guardian that really has done outstanding work through their extraordinary efforts. This year, we're doing things a little bit differently. So I'm not going to be announcing the Guardian of the Year Award yet. I'm going to pass it on for a little bit later. It is a secret, by the way. There are the build-up. There are only a handful of folks that actually know who is the recipient. The vast majority of the judges and the general magistrates only vote. We vote anonymously, so they do not know. But we're going to pass it on a little bit later. Additionally, I wanted everyone to be able to get just a little bit of a glimpse of how important it is to take on a case as a guardian. It's hard work. It's such rewarding work. You've heard it. We, the judges, the general magistrates, we would not be able to do what we do without guardians' work. And we are so grateful for this particular event. You've heard it before, but I have to say thank you to Jerry, thank you to Dade Legal Aid, thank you to Karen for putting on this program. We need folks to accept cases, and we're so grateful for the work you do as a guardian. So this year we've asked someone just to talk a little bit about why they take on cases, what it means to take on cases, and if you want to consider taking on a case. And then we're also going to be announcing the recipient in just a little bit. Okay? I hope I know everyone is just wondering who it's going to be, but we'll announce it in just a few minutes. We continue on with the agenda.
After these messages.
That's correct. We're taking on a break now. This is the break. This is the break.
Shout out. Of course. Love you. No, I'm done.
Whatever she wants me to do, I told her whatever you need.
Okay. It should be nice. Oh, now we take the picture. Whose is that? Oh, whose is this?
Sam's.
Okay.
Se le cayó.
I know. Put it on. Oh, let me clip it on.
Congratulations. Celebrate with you.
Did you say it's sticking the hair?
Huh? Yeah. Hey, cuesta.
She told me she excused him.
I just, yo te mandé lo que me mandó él, verbatim.
Let me tell.
Entonces, when I text him,
Let me text her.
he says he got kids. He says he got
The traffic was really bad.
No.
Everything was bad today. Yes.
Dice la gente buena. Bien, ¿y tú?
Muy bien. Te quería presentar a mi hija. que es
Oh,
abogada.
mucho gusto. Jorge Sergio, un placer.
Oh, how are you? Very nice meeting you. Very nice meeting. Hello. Very nice meeting you.
Nice to meet you.
So nice to meet you.
Yes, he's the best. I know. He always talks about all of you guys. He says you guys are all the best.
He keeps us out of trouble. And I try to get him in trouble, but he doesn't let me.
No, I can't.
You're from Malito, because every time we're back there, they'll do something.
Yeah,
pero-
no. Todo tranquilo.
Well, he
Tranquilo,
loves,
tropical.
he loves his job. He always says how much he loves his job. And he loves working with all of you. Yeah.
Very nice meeting you.
So nice to meet you.
Same here. Thank you for coming.
Of course. No, thank you for having us. That's so happy to visit the firm.
¿Por qué?
And you know what? But I know she has to take a break.
I just texted her.
Well, because she's got a workflow report map. I know her schedule. She has to take a break from that child and jump into that meeting. So that should be the time that this would be.
They're like cats. You open the door, they run out.
Well, we'll just do us for now. How about the part of the bench?
Yeah.
We'll do it.
Let's do it.
Here.
Yeah. Yeah, we're gonna have Jerry.
That's okay. Or maybe he's mistaken. No se dio cuenta. Maybe he didn't know.
My flight got canceled. So I have to go there for.
So I haven't seen you in forever, man. How you doing? You're like big brass over there. You don't come over.
You know, I don't have any cases anymore.
That's what it is, yeah.
Volunteer programs.
Yeah, I heard. Yeah, I mean, that's what I said. You're big brass.
I had like a 4-day trial with you and I dropped the mic and walked out.
That's the way to do
I
it.
really did, actually. I told my wife, that's it. I did a relocation with you in Zoom for 8 hours. And I just don't, and my wife was listening, and I just walked out. I literally walked out like this.
You don't miss it?
I do. I do.
You're good at it. That's why I figured you would.
I do miss it a lot. And I might go back. For
are getting to Raleigh. And then we fly back from Raleigh. So hopefully that doesn't get canceled. But now I get to go to the airport and get a rental car from the airport because we can't drive our car because we're not coming back from Vegas. So hopefully by now this brings us to
No, I'd like to try some cases. I might take a couple on. You should.
Well, you are.
I will. Keep the juice flowing.
You know who I see when I come down here all the time? I see
So I came in.
Oh,
with
yeah.
cargo.
I always see him on
He's
the
always
street.
wrong.
Hello? If you all can do me a favor, to the people that are outside, if you can help by getting them to come in. There is a jury trial going on in one of the courtrooms over the side, and they've reported that it's getting a bit loud, and lawyers at that courtroom are having a hard time presenting their cases.
So why don't I get all this stuff out of here? Okay, 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 okay. So this is okay if I put these right here?
Good. Oh, we've been getting it. Thank you.
Are you recording it too?
It's streaming, and yes, it's
It'll be recorded.
right. Exactly. Nice. Don't even say that.
Just joking.
See, now you have to walk the building twice backwards. Check 1, 2.
They're really gone. We're going to start the panel. We'll just go. Are you, okay, we're going to start now. Judge Sardui. I'm sorry, Judge. If you don't mind. You want to sit? You guys sit down? I don't know if we do. We're having a little bit of an abbreviated session this morning because of a travel problem. So what we're going to do is just have a discussion. With Judge Ruiz-Cohn and Judge Sardui, who are the, Judge Ruiz-Cohn is the administrative judge, and Judge Sardui is the associate administrative judge. And welcome. Thank you. Every year they come. For those of you that don't come every year, the judges come and they tell us a little bit about what's going on administratively in the court, what they're seeing, and what you probably are seeing in your cases. So, Judge Ruiz-Cohn, since last year we talked about the new rules and the timelines and all that stuff. So, what has happened since in the last year?
So we continue in the division, and when I say we, it's the judges, the general magistrates, and we meet every month to discuss any issues that may be coming up in the near future. Of course, we continue our training program. It's something that's very dear to me. Training is, I think, integral to the family division. It's why we offer 2 trainings every month to all the judges and the general magistrates, where we apply for CJE and CLE credits. One of those 2 trainings, it's just the judges and the general magistrates. And then the second one is what you all know as the Lunch and Learns. And our Lunch and Learns have, in particular in the last year, have just exploded. Our average attendance is over 100 lawyers, 120, 130 lawyers. I have judges from other divisions, from civil, county court judges that are asking, I heard the topics are great, can I attend? We have a lot of lawyers, a lot of guardians that attend. And I really attribute that to the topics and the presentations, besides the fact that we apply for free CJE and free CLE, and it's on Zoom, so it's nice and easy. But the topics are excellent because they can range from introducing bank records, Judge Diaz and I did that a couple of months ago, to the ethical considerations of a guardian. So the topics are wonderful. The judges and the general magistrates continue to really be on top of the cases. We're very much aware that the Florida Supreme Court has made it very clear that judges in the state of Florida really have to move their cases along. We utilize the case managers, I think, in a very effective way. We move our cases along through case management and through orders. Orders to progress, orders granting those motions that have been filed. Last year we discussed about the days of filing a motion for extension of time to file an answer, for example, and filing the motion and not noticing it. Those days are gone, because if you file the motion, you very well may get that order granting your request, whether you notice the motion or not. So we really move the cases along. Of course, the rules recognize that even though the majority of family contested cases should conclude in 180 days, and I know every time I say that, I get folks that are saying 180 days. That's the rule, 180 days. But it's not, the rule does say that it's the majority of cases, and it recognizes that there are some cases due to their complexity that will not be able to conclude in 180 days. So I encourage lawyers that if you believe you have a case that is complex, to make sure that you seek that finding at a case management hearing, so to make sure that you can slow down the case
Well, that
somewhat.
raises a question. In one of our cases, we filed a notice of complex case or something like that, and it went before the court, and the issue was which rules apply, right? Because there's civil rules that have to do with complex litigation,
Yes.
and they're right, and
Yes.
that's it. And the family rules are, I don't know. I think it says the word complex somewhere in there. So how are you dealing with that? Are you just?
It's up right now, so there's no case law specifically on it. The rules talk about complexity. So I think it's up to each judicial officer to determine whether it falls under a case that, due to its complexity, is unable to conclude within 180 days. So it's going to be discretionary, but I think it's extremely important to make the court aware. If you know that you have that case that has a domestic violence case attached to it, that has numerous issues that realistically it's just impossible to conclude within 180 days. I think it's extremely important to let the court know and the reasons why.
You know, from a lawyer's standpoint, I'm sure all the lawyers have these kinds of feelings. As you get into a situation where...
And so do the judges.
And so do the judges, I'm sure. So, you know, you get into situations where your case, the people don't want to move it. The lawyers don't really want to move it because it isn't really a litigated case. It's a case that got filed. And then we're dealing with, you know, you get an order to progress, an order to file a financial affidavit, an order of mediation, et cetera, et cetera. And we wonder if the court understands that there are those cases and that I'm sure there's some of you out there that it's difficult when you get the order and you say, like, what do I do now? I haven't even spoken to the client in 2 weeks and I have to do something in 5 days, for example. So are you guys aware of that?
The answer is yes. I think what's important is certainly not to ignore an order. If you need an extension to just upload an agreed order, most judges will, I think, be very sensitive if you have uploaded an agreed order to extend whatever deadlines there were. Most judges will be very sensitive to that. And if you request a case management conference, that also will, I think, assist the court. As long as the case, I think, is moving along, I think that is going to go very far into the case management aspect of the case.
Thank you. And Judge Zardui, I believe you've pointed out that there's a problem with the RUCDs, and could you discuss that?
It's not necessarily a problem, it's just something I've noticed.
Okay.
First of all, last year I remember saying, wow, we're in the Dade County Courthouse, courtroom 6-1, where Al Capone was tried, where Giuseppe Singera was tried for attempting to kill was he president-elect or president at the time? And I thought last year was the last time we were here, and here we are again. We're saying the same old thing, so. But apparently this time it's real, so enjoy it, because this is a very historic place, a lot of history in this building. And like Gina was saying, I'm also a history buff, so it's fascinating to be here. Yes, as to our remote UCD calendars. So for those of you that know me, I prefer to have that people present in UCD. And in fact, Mark and I, we were talking about it. I found it one of my favorite calendars, the other one being adoption. Adoptions are truly the best. But UCD was normally fun because, listen, this is the end. And for most people, they were happy. I had some people that would come drunk, offer me champagne, which, you know, we all know that you're not allowed to, which we might need to amend the rules for that. Some people seemed that they were happy because of ingesting other things. I don't know what. Because it's, you know, really the end of it, and they just like the process of, you know, hearing you're officially divorced. But we did away with that. COVID, one of the things that did away with that, and I think we've become more efficient, right? Because now you guys submit paperwork, you don't have to drive down here, your client doesn't have to be here. I'm blaming you guys because you're depriving your clients of that opportunity of joy. But there's a problem, at least I've found. And what's the problem? In the old days, I know the lawyers, and I'm going to pick on Mark because I was talking to him earlier, and he's a buddy. Mark would come, he would come with his folders, and he's not unique, all of you do this, come with his folder, and he would bring me everything that I needed. If there's children, he's giving me financial affidavits, he's giving me the parenting plan. If there's assets and debts, he's giving me the MSA. He's giving me a proposed final judgment. Sometimes he'd bring me extra copies so we could conform. He'd give me everything that I needed. He'd bring me the driver's license, a copy of it, make sure that we have jurisdiction, right? Not just a copy of a driver's license, but as we all know, 6 months prior to the date of filing has to be in place, or if not, a voter registration card or a Florida valid identification card. Thank you, Mark, you did all that. But nowadays, it's a little different. Nowadays, what I think is happening is that the lawyers are giving it to someone to upload it. And I'm not so sure that the lawyers are aware of exactly what's being uploaded. So what do we get? It's like a recurring. If I get a driver's license, it doesn't establish jurisdiction. So we reject it. Now we have the Rule 2.250 with 180 days. It's set, this hearing is set for today. You're not giving me the stuff that I need. What do? I dismiss it. Because I hear the ticking clock behind me. It's like it's always behind us. Sometimes they don't give us anything. You have children. Well, we want financial affidavits. We want to see the child support worksheet. It's not attached. What do? Do you reset it? Or I didn't set it, they set it. They're just not giving you everything. You dismiss it. I would ask you guys to please talk to your people and make sure that they abide by the requirements of the division. And this is where it gets a little hectic, and I understand that. There's 14 family divisions, right, Sam? And I think we have like 16 different procedures, okay? And it's problematic because everybody does things a little bit different. But you need to become aware of how we do it, because following up with that rule that Sam was talking about, that 2.250 is just breathing down our neck. And if the paperwork is not there, I don't know how my distinguished colleague does it, but I dismiss it. I expect the lawyers to move to vacate and give me everything that I need, and I give them a rejection. This is why I rejected the final judgment, and the next order is dismissing it because they didn't submit it what they needed to submit. So that's the one thing that I see a lot of little wrinkles with.
Okay, thanks. Well, while we're talking to you, Judge, what do we do when we're trying to get a hearing and you know, you're told, every division is going to be different, but you know, you're told there's 3 dates, for example, and the opposing counsel is not available. And then you get 3 more dates, and the opposing counsel is not available. We had one where there were 13 straight dates that were rejected over 2 months, for example. What is the court, you know, does the court aware, again, it's another one of these things, so as practicing lawyers, you wonder, do the court know about these things? What's the best way for a lawyer to get that hearing? Because you don't want to be a tattletale. You don't want to be, you know, a bad person and just keep saying this person is doing something bad. So what do we do?
You know, it's not being a tattletale. And to be honest with you, I'm here today right now with you. My judicial assistant is over there, and she's doing 500 things. I can't tell you everything that she does. I understand I have the little Truman plaque where it says the buck stops here. It's my responsibility, but I honestly do not know unless it's brought to my attention. I mean, my JA runs my life, everything. If she's unhappy, I know, because I see the type of cases she gives me and the type of breaks she gives me in between. So she runs everything. So, Mr. Kornreich, honestly, I think you need to put it on calendar. And sometimes it's not really like a tattletale motion, and I understand, I know your style, you're not gonna do that, but sometimes it's just, hey, can you help us schedule something? You put it on motion calendar, we spend 5 minutes, and normally by that time, if it goes, because sometimes opposing counsel gets the message, hey, this is not gonna go over well. And part of the reason is, again, the 2.250 rule, because they know when they come in, that's gonna be my stump speech. Hey, the case is pending for this long. Why isn't this happening? Why isn't, you know, have we gotten to mediation? Why not? Well, we need depositions and this. So they understand they don't want to have that conversation, and normally they will buckle, but if not, I'll gladly help you schedule. I don't have a problem doing that. And it doesn't have to be phrased like, you know, they're being impossible, but we'll read the tea leaves. We understand things happen, but we got to move the cases.
Yeah, thank you. Hopefully that's helpful to some of us.
And there are tools available specifically, and everyone has seen it. I think everyone in this courtroom has had a case, or 2 or 3, right, when you're trying to schedule a hearing, and the other side is not available all of a sudden for 4 months. Or you file a motion for temporary attorney's fees, and the other side is not available for 8 months. Or they file an emergency motion that in no way, shape, or form, under any understanding of the case law, could ever be an emergency motion. There are tools available. For example, Judge Sardoui mentioned, you can file a motion to schedule a hearing and notice it on the motion calendar. Now, you may be thinking, yeah, but Judge Ruiz-Cohen, how do I get it on the motion calendar if they're not agreeing? Well, you see, first of all, know your audience. Go to the judge's website. There are some judges' websites, like myself. On my motion calendar, all you need to do in order to schedule a motion is an attempt to meet and confer and 7 working days' notice. That's it. And there's also language that a party may unilaterally schedule a motion if there's been no response on an attempt to meet and confer. Which means you send the email to the other side, are you available for the motion calendar? And then it's crickets, That's your attempt to meet and confer, 7 working days, you notice it on the motion calendar. And when the other side emails my JA and says, oh, they unilaterally set it on the motion calendar, she's going to read it, she's going to show it to me, and I'm going to say, we'll address it on the motion calendar. And then I'm going to be asking, why exactly are you not available for 6 months? So that's one tool that is available. The second tool that's available is absolutely email the JA. There are some judges, and I fall under that group of judges, that when you email the division email, the judge gets included, be CC'd, which means in my division, when an attorney is being rude and obnoxious to the other attorney, and then including my JA, I'm seeing that. If my JA has offered 4 sets of dates, and still the party that's opposing the motion is not available, that's going to be set on the motion calendar. My JA also, even if you don't file that motion to schedule the hearing, after she has offered, and she usually will offer 3 set of dates, if she sees that the attorneys cannot agree, she will phrase the email in the following format. Here are the last set of available dates that the court is able to schedule via email. If you still are not available, you may schedule this matter on the motion calendar next week so that the court can select a date for you. And then all of a sudden, everybody is available on the last set of dates. But know your audience, go to the judge's website, know how the judge is going to handle it, and certainly email the JA. The JAs, I mean, they're our office managers. They're going to tell us, and feel free to file that motion on the motion calendar and look at the judge's website, because you very well may be able to just unilaterally notice it after you attempt to meet and confer and give notice.
And one thing I'd like to add to this, it's absolutely true what Sam's saying is, listen, we do motion calendars now via Zoom. It's very difficult to say I'm not available. I mean, it happens, but it's not really, because I have hearings where somebody tells me, hey, I need to take a break for a moment, I have to appear for a motion calendar. It's like, okay, we'll take a break. Why not? Give you 10 minutes and you get it done. So it's you're not driving down here, so there's good in this Zoom, right? But there's bad. That's the bad part. It's hard for you to say I'm not available. 5 minutes is not really a big deal. And if you can coordinate it with the office, like with my bailiff, you can just let him know, hey, listen, I have other hearings. Give me an idea. Can you text me when he's, when I can come on? He'll do that. We'll do that. We'll work with you. So it's going to be tough not to make yourself available.
Very hard.
Yeah.
My motion calendar is at 8:45 on purpose, so that it's really hard to tell me that you're not available for my 8:45 motion calendar on Wednesday and Friday. Maybe one, but both Wednesday and Friday you're not available at 8:45. The next question my Jay is going to ask is why? Why are you not available at 8:45?
And with Sam, we started doing the 2 motion calendars a week, so we've even opened up that door. So come on, maybe one, but both? I don't know.
Well, that's really useful, and thank you. In conclusion, because we're running short a little bit, have you noticed, one way or the other, if more cases are being tried?
So I think from the attorney's perspective, it may be a little bit different than from the judges and general magistrates' perspective. Remember, we're scheduling for trial everything that is getting ready for trial, right? So our prism is a little bit different. What I personally have definitely noticed, unfortunately, is that after 2020, folks are really angry. They're really angry. And often, they're not nice to each other. Sometimes they're not nice to the court. And that, I think, plays a factor as to whether there's going to have to be a trial, because I do see the recurring theme of there's resistance to go to mediation. There's certainly a resistance to have the right frame of mind. And I think that trickles down to how likely the case is to have to go to trial as opposed to come to an agreement. There, talk about professionalism and giants in our field. There are some cases that when they come in with certain lawyers, that there's a very high chance that that case is going to settle. You just know it. You know it because you know how the attorneys practice, and you know that are you guaranteed? Of course not. But you know that there's a very good chance that it's going to settle and it's not going to end up at trial. So much that I will sometimes double book and put a standby case if I have certain trials set with certain attorneys, because I'm pretty sure that it is going to settle. But unfortunately, I think we are still seeing post the pandemic where folks are just angry. They're very, very angry, and family, it's raw. I mean, I don't have to tell anybody here. It's raw. Folks are, and we are making decisions every day as to whether and how folks can see their children, and decisions on folks' bank accounts and wallets. And when you add to that they're angry, they're really angry, that unfortunately I think does trickle down.
I agree with her, yes, absolutely. They say some of the biggest stressors in your life are your job, your home, and your work. Well, we're messing with 2 out of 3 and sometimes all 3. So people aren't happy with us. And yes, I don't know if, by the way, Sam, I did notice that too. Since the pandemic, I've seen like an uptick on this, and I don't know if the AMA has listed potentially as a side effect of COVID to be angry or something, but it's there. I mean, it's the lack of civility and the needless desire to litigate something that could just very easily be resolved. It's there, so.
Well, thank you both so much. Thank you very much.
Thank you, guys. Thank you.
I tried to keep you on.
I can return them. Yes, return.
No, it's fine.
Do it, or you don't care?
No, it's not, I wouldn't say I wouldn't care.
Can I look at their scratch? Oh, the same place.
And I'd like to introduce our last presenter. First of all, that was great, judges. Hopefully that's helping you guys. If you have questions, you should sometimes send it to people, anybody. You know, the relationship issue is real. Send it to somebody else and say, can we ask the judge about that? Because a lot of us get caught into the same problems, and you don't know how the judge feels. So, you know, it's good to hear this kind of stuff. I'm sorry. Oh, you want to do it? Okay. Okay, we have a surprise.
Our next,
sorry.
we are calling things out a little bit out of turn. Our next presentation, I mentioned earlier, we wanted to get some thoughts from a guardian as to why he's been doing this for so long. So we have Dr. Furby. Dr. Furby, thank you very much for coming up. If you'll please join me. Dr. Furby, everyone knows, has been a guardian for decades, and we couldn't do our job without the guardians. So we wanted to get a little bit of his thoughts on why he's been doing it for so long, why he continues to do it for so long, and why what he enjoys of being a guardian.
Okay. A little bit of torture and a lot of understanding that what happens in these cases is fundamental in the life of these children. If I may just do an anecdote. I got a call yesterday from somebody, a father who was involved in a case in this division a long time ago. And it was a really hard-fought case. I think Judge Verdi was the last judge. Horrible case. One of those cases that wound up in Bridges for parental alienation. Family with resources. And the resources were used to litigate and litigate and litigate and litigate. And there was a wonderful guardian on that case. I was a social investigator, but there was a wonderful guardian in that case, which is a very interesting interface when you have a guardian and a social investigator, and we can talk about that and how that works. I've done it with Maria. I got a call from that father years later to tell me that the daughter had finished her schooling at an Ivy League university and was doing, if you will, a thesis on issues having to do with family court and children rejecting parents. This is a kid that could not stand the sight of her father. The boy, who everybody thought was going to go the completely wrong way, turned out to be the most insightful young man and is at one of the best business schools in the country. And the little one is applying to the best universities in the country. The mother and the father, who spent millions of dollars, this case was in the millions of dollars, talked to each other. They all apologized to each other. And the fascinating thing is that I know that the guardian ad litem was instrumental in that family in setting things up, in getting them to settle, in getting them to understand that while things were terrible now, there would come a point when kids would understand what was happening, where kids could absorb what was happening, and it did. And I know this young lady that is now ready to go to law school could not stand the sight of me because I was saying things as a social investigator that I had to say. She's asked to speak with me because she needs to go back and understand how this whole process affected her. But the guardian was the person that was, if you will, in the middle of the fray and watching out for the children and making sure that their voices were heard, even though what they were asking for may not have been what they were mature to ask for at that point. Guardians?
Absolutely, absolutely. So I mentioned that the Guardian of the Year Award is an award that is an extremely prestigious award and is a secret. And I am delighted to be able to announce the recipient this year. It's someone that I have learned so much from, who has, he didn't know, really has just been extraordinary in terms of his work. And we asked him to do a brief presentation to get him here. So, on behalf of the 11th Judicial Circuit, I want to congratulate you. As the recipient of the Ray Person Guardian of the Year Award. I know. Thank you, Dr. Furby.
Thank you, Judge.
They want a picture.
Nice surprise.
Huh?
You surprised?
Second time, yeah.
I know that. Thank you for coming. That's our tradition, to surprise people. It's a Our last speaker is Maria Gonzalez. Maria has done everything, literally everything. She's led everything. She's created everything. She's written everything. She's extraordinary. She was president of the Inn of Court. She's president of the family law section. She's just, she's the head of, I don't know, vice something of the Family Foundation. She's just really, really one of the great lawyers and examples for all of us. And she's going to do the case law update. Thank you. Right.
Thank you, Jerry, for those incredible words. And I want to thank Judge Samantha Ruiz Cohen, as well as Dade Legal Aid and Karen Lattis for giving me the privilege to present, which I love to do. So today, let me see if I have this right. There we go. So I got to tell you, this year was not that exciting. Okay, I don't know, maybe you'll find some of them exciting. I have two that I think are kind of cool, but the rest were kind of like, you know, I tried my best. Again, I'm going to give you a potpourri of some of the cases. The first thing you have to be aware of, I got to tell you, paternity cases are just incredible on the appellate side. And I think on the trial level as well, many of us are getting them, and it's showing up, it's evident in the appellate cases. So be aware if you are doing any appellate work or any paternity cases, we now have a conflict. And I'm going to go right into it. What is the conflict? Attorney's fees at the appellate level on a paternity case, and that is Chapter 751, 752, 742. So what are the two statutes you need to be aware of? Chapter 61, 6116 says very clearly that the court can award attorney's fees from time to time, et cetera, et cetera, et cetera. And then at the very end it says, and appeals. So you can get it in modifications and enforcements and your regular case, but and appeals. That language is lacking. It is not under Chapter 742. It's not there. So that has created a lot of problems. Very simple, right? Two words. I did this beautiful chart to let you know how conflicted this particular issue is. And our district, 3rd District, we just joined the party. We just did. If you look at the starting date, it was in 2013 that the first case was decided on this particular issue. Is a party going to be entitled to appellate fees in a paternity case under Chapter 742, which we all know used to send you to 61, now has its own statute. So the 2nd, 4th, and the 5th are all aligned. If you practice in those circuits, you will and you can get appellate fees. If you practice in the 3rd District or the 6th District, you will not. So know where you're practicing. The update on the 3rd District case, which is the Perez-Palma versus Rodriguez, the Supreme Court of Florida just took jurisdiction. They accepted jurisdiction of that case on October 22nd. The briefs are due next week. So those folks are typing and writing it right now as we speak. An oral argument will be probably in the spring. So I suspect we're going to have a decision probably before the end of the year. So the 3rd District in, I think it was in September, they certified conflict with the 4th and the 5th, and then that resulted in a very rapid, it was like 3 weeks, and the Supreme Court said, yep, we're listening to it. So just be aware of that. The next case I want to talk about is a case that talks about, it looks to me that this is one of the very first cases, appellate cases, that is looking at The 2023 amendment to Florida Statute 744-301, that made a difference there as to whether a father is going to have establishment of parental rights as a result of having a voluntary acknowledgement of paternity. So it was a significant amendment in 2023. And here, clearly, the father does have custody rights because he did have with the mother the voluntary acknowledgement of paternity. And the case says very clearly that the father's paternity was established by operation of law. And that's important. Why is it important? Because then you don't have to go across the street and file and go to circuit court to have a whole full-blown hearing to establish paternity. You can skip that. So the rights are there, and it's significant. It's a really significant case. Our next case is the Butler versus Butler case. It's a DOR case. If you opt for judicial review, then the administrative procedure stops. And what's the remedy? In this case, they didn't stop, even though the department, to their credit, confessed to error and recognized that the party that was being served and they were going after for child support had in fact timely filed a waiver, so that they had 10 days, they did their waiver within the 10 days, but nevertheless, the department went forward, they got an order, so the remedy was vacate the order. But it's important, and sometimes you may get a call from a client, and I know the notices say all of these deadlines, but that is a very important one, and you can stop the administrative process. So that's the proposition of that case. These two cases, again, this is all parentage. You have the Bauer case and the Bronner case, and they're very similar. The reason I put one of them on 2024 is because they end up with different results. They are very lengthy opinions. They even go so far as to, there's so many petitions being filed by the biological father and by the legal father, and there's crossover. He filed this, he filed the other thing. Even one of the parents in one of the cases, one of the fathers rather, filed for a disestablishment. So, and the court said, no, you can't do that because you're not the father. You haven't even been determined as the father. How can you possibly jump over here and try to disestablish something that you don't even have the right to disestablish? So I encourage you, if you're doing paternity cases, to read them. They're very, very, very long. In one of the cases, the Bauer case, the mother requested a DNA test, and the court said, no, you're not entitled to a DNA test. We're not wasting time on that. You don't have a right to that. Why? Because you signed a voluntary acknowledgement of paternity. And you have to go to that statute, and it tells you exactly what it is you need to do. It's nothing major. You have to have 2 witnesses, you have to be notarized, and you have that 60-day window to repeal it or to take it back. So if you complied with it and you did it, that is hugely significant. These cases are all telling us if the voluntary acknowledgement of paternity exists, it is so significant that the legal father is precluded from coming in, knocking on the door of the courthouse and saying, guess what, I'm here, I want to establish my paternity. And they're told no. So this case, at the very end, I added, the court dismissed with prejudice, which is the significant part. They dismissed with prejudice in the 5th District the legal father's petition to establish paternity. And it got reversed because they wanted to permit the biological father to have an opportunity to plead the one and only basis to challenge the voluntary acknowledgement of paternity, and that is fraud or duress. So they kind of said, okay, no, you don't have any rights, but because the court made it with prejudice, we're going to give you another bite at the apple, and if you can prove it, then you might be able to come in. So very important cases, I think, to be aware of. Our next case is, this is going to be just like remembering what we've already seen in prior years. We all know your parenting plan, be careful, be thorough. You must include in the parenting plan the specific time-sharing schedule. If it's not there, it's going to be reversed. We had prior cases. This case did not talk about holiday time, but we've already discussed previously. Remember, we had a prior decision where the parenting plan was silent as to holidays, or said something to the effect of, oh, well, the parents will call each other. They will determine the holiday in the future as they deem fit. That's not satisfactory. So under 6113, the court must specify the time-sharing schedule. And then in addition, one of the other findings of this case, or rulings, is that the court can never delegate. We cannot delegate to a therapist and make a reserve jurisdiction and say, well, I will make the final time-sharing later when the therapist says green light. That cannot happen. And lastly, this case, again, teaches us how important is it to include your findings of fact in your final judgment. Huge. So when you do your equitable distribution, make sure that you indicate the distribution of all the marital assets and liabilities. Don't leave any of the assets or liabilities out. Are they going to be distributed equally or unequal? And what's the basis for justification for that? Clearly identify whether they're marital or non-marital. And here, with the imputation of income, there needs to be an adequate finding as to imputation of income, not just, well, I'm going to impute income. And it's your job. You're drafting the final judgment. This is an interesting case. It dealt with a foreign judgment from Venezuela, and the parties lived, I believe, in Texas and then ultimately ended up in Florida. The father obtained an actual Venezuelan final judgment, and then he wanted to domesticate it here. And there was a motion to dismiss, and the error here was that the court, in considering the motion to dismiss, went outside the four corners of the petition. What was it that the court looked at? The court was looking at the Venezuelan judgment, and you can't do that. So it kind of tainted the whole process, right, of what the court should have been looking at on determination of the motion to dismiss. And the other aspect of this case is that they determined, because it was very fact intense, that the court, the Venezuelan court, ultimately, that the father had obtained, husband, had obtained a decree of divorce, never had personal jurisdiction over the wife. And she was not domiciled at the time, nor was she properly served. The service is hysterical. If you read it, there's a cousin, and there's a P.O. box, and there's a dog, and a this or that. It's ridiculous. It just goes on and on and on. So lack of jurisdiction also over the children, because Venezuela was not their home state. Our next case here is a DV injunction. Before I go into the specifics, the factual part of this, how many, by show of hands, how many cases have you dealt with where there is a teenage child, a cell phone, an argument with a parent, and a domestic violence injunction or a petition? There we go. Horrible. This is just, it's repetitive and repetitive. And I will tell you, once I get through with this case, I've had 2 of this type of situation. So this case is a 4th district case. The father is a post-judgment. They have been divorced for 4 years. The little girl's 14 years old. She comes home from some party or something, and the father goes to the book bag. He finds marijuana and a vape pen. And he says, guess what? My parental punishment is give me your cell phone. And the child says, no, I'm not giving you the cell phone. They struggle. So imagine they're struggling. She ends up with, the evidence says that there's some bruising on the child's hand. What I found, a little bit like a bruise, but I'll tell you, I'm going to read some specific findings here. Astoundingly, in that little hand struggle with the phone, the child actually fractured and broke the father's finger. They struggled. The mother then, remember, mother, former wife, filed a petition for domestic violence on behalf of the child. The trial court granted the domestic violence injunction to protect the child against the father based on the daughter's fear of being forced to spend time with the father. The 4th district reversed and the granting of the DV and said that the father's actions were in trying to get the cell phone amounted to, quote, appropriate physical discipline. It was not domestic violence because it was reasonable and not non-excessive parental corporal discipline and not domestic violence as a matter of law. So that is your cell phone case. It is sad that they even exist, and it's sad that it has to go up on appeal, and it happens. Now, I will tell you, the first time I was appointed as a guardian ad litem on a cell phone DV case, it was post-judgment. It was a 13-year-old little girl. The mother disciplined the child, and what she did is she didn't touch the child. She screamed, probably, yes. She got the cell phone, and she had been doing some work around the house. She got a hammer, and she hammered in front of the child. Like, it must have been horrible. She broke the phone, like right in front of the child, destroyed it, and that was a DV injunction. It was in a different circuit, by the way. Just to be clear, it has nothing to do with the third district. So judicial notice and hearsay, this is, I think, just a refresher. We all know in our cases we have police reports, social investigator reports, GAL reports, all kinds of stuff, business valuations reports, things that come in. And if you file, or your opponent files a notice to take judicial notice, let's say, of the entire court file, that could be tremendous. Be aware what the heck is in there. Are you okay with the judicial notice of just the court orders or the kitchen sink? So you need to probably object and protect the record, because some of those items in the notice to take judicial notice of a file may have inadmissible hearsay. So you need to kind of carve that out and not just say, well, everything comes in. So just be vigilant of that, I think. The next case is a paternity case. Guess what, right? Surprise. The father here appealed the amended final judgment. It's simple. Did the mother plead and raise the issue of retroactive child support? She did not. Not only that, the father raised an objection when the mother tried to come into and put into evidence, I would assume, some sort of schedule or proof of what the retroactive child support was. He objected, which is great. So he protected the record. There was no express or implied consent to that issue being tried, but yet the court made a finding and awarded retroactive child support to the mother. So that was reversed on those grounds. So object. And this didn't mention anything about pretrial stipulations or things of that nature, but I would imagine there must have been a pretrial stip as well. This case is kind of reminding us that the Zold case is still very good. It's a 2005 case, which really dates me a lot. And the 5th District here reversed, because in that case, and the testimony was really very specific. The father's testimony was unrebutted. He spoke about his corporation, about why he was retaining earnings in the corporation, and that's one of the 3 parts to the Zold test, which is it a corporate purpose? And he satisfied that, but yet the findings in the final judgment were adverse to it. And the 5th District said that no competent substantial evidence supported that the trial court's finding that the father had not testified or provided any testimony as to justifying why the company was doing retained earnings. So that purpose for this, it was income for child support purposes. This is interesting because we all have social media, right? And we all know our clients love to give us, like, do you want to see the text messages, the WhatsApp? I had 250 pages printed double-sided as an exhibit in a case of WhatsApp, because that was before OFW. It is horrendous. So this 4th District case, they reversed the court's valuation of the marital vehicle. Why? I don't understand why there was not another satisfactory method of proving the value the value of a vehicle. So in this case, what was the evidence? The evidence was the former husband wrote to the former wife and said, quote, I have done some brief research to put a value on the car. It's, quote, around $38K. And then he was, quote, willing to negotiate, and in which he offered an agreed order, again, quoted. That's straight out of their text message. And then on a motion concerning the vehicle, if the wife was willing to wire him a specific amount. So in other words, I want to negotiate, I think it's 38, you tell me what you think, blah, blah, blah. They go to court, and believe it or not, this is incredible, the only evidence of the value of this vehicle was the text message. That is very sad. but it is what it is. And the value was not supported by competent substantial evidence. So the trial court should have sustained the former husband's objection to the text message. It was inadmissible. It was evidence of a settlement negotiation. So that to me is like, right? It's wild. So our last case, which I left for last as our treat, what do we need to attach to our final judgments? Child support guidelines. I attended a hearing this week, final judgment on Monday, in this circuit. And the parties testified uncontested. And they said, yes, everything's done, da-da-da. Do you have the guidelines? And the attorney, I was the guardian ad litem, by the way. No, Your Honor, we don't need guidelines. What do you mean we don't need guidelines? No, because he's not gonna pay her, she's not gonna pay him. And the judge said, very nicely, I need guidelines. So please, download the guidelines. This opinion also says it either has to be attached or it can be within the final judgment. I like to attach it, but I guess you could comply if you put all the language and all the necessities of the guidelines within the judgment. But that's what this proposition stands for. And every year that I lecture, there's not a single time that I don't bring this up, right? Because it keeps happening and happening. So I want to thank you all. We've covered everything, and I told you, I hope you liked some of them. I hope that some of these will help you with your practice, and thank you very much. Thank you, Debbie. Yes, oh, my little photo.
Yes.
Ooh, I got a big one.
Oh, we're doing, Jerry.
Here, I'm gonna take my little glasses off here. One second.
By the way, we're finished.
Thank you.
So
Thank
come
you.
next year in the new courthouse, okay?
Thank you, Karen, for the lovely plaque. It was lovely.
That concludes the program. If you want to sign up for a pro bono case or a guardian ad litem case, come see us. We will train you, mentor you, provide additional materials from today. Court is adjourned. Thank you for attending.
Yeah.
Steve, don't leave. Yes, we're taking a picture with all the judges and JMs. Judges.